Here's a question I want you to answer honestly right now before we go any further. If you passed away today, do you actually know with certainty who would inherit your home, your savings, and everything you've spent your entire life building? Most people assume the answer is obvious. Of course it goes to my spouse, or of course it gets split evenly among my children. But here's the uncomfortable truth this video is going to walk you through. If you don't have a valid will, the answer to that question isn't decided by you, by your spouse, or by your family at all. It's decided by a formula written into your state's law, a formula that has never met you, knows nothing about your actual relationships, and applies to you exactly the same way it applies to every other resident of your state, regardless of how your family actually functions. My name is Finn, and this is Finn Retires, the channel that exists to make sure the things you've spent a lifetime building actually end up exactly where you want them to. If this is your first time here, please hit that subscribe button right now before we go any further. We talked in a previous video about how a beneficiary designation or a property title can quietly override even a carefully written will. But today, we're going even more fundamental because a significant number of retirees watching this video right now don't have a will at all. And I want to make sure you understand exactly what happens to your money and your family if that describes you. So subscribe, stay with me, and let's walk through exactly what the government decides on your behalf if you never make this one decision yourself. Let's start with the number that I think should genuinely concern every single person watching this video. According to Caring.com's 2025 Wills and Estate Planning Study, only about 1 in 4 American adults actually has a will. Not 3 in 4, 1 in 4. Which means the overwhelming majority of families in this country are relying, often without even realizing it, on an entirely different system to decide who inherits what when someone passes away. That system is called intestate succession, and I want to walk you through exactly how it works because the specifics genuinely surprise most people who assume they already understand the basics. When someone dies without a valid will, their property doesn't go wherever they might have casually mentioned to family members over the years, and it doesn't automatically go entirely to a surviving spouse the way most people assume. Instead, it passes according to a rigid, predetermined formula that every single state writes into its own specific laws. And this formula is applied identically to every resident of that state, regardless of their actual family circumstances, their actual relationships, or their actual final wishes. There is no federal intestacy code. Each state decides its own rules, which means the exact outcome for your family depends significantly on which state you live in when you pass away. Here's the first detail that catches most people completely off guard, and I want to spend real time on it because I think it's the single most misunderstood fact in this entire topic. Most people assume that if they die without a will, their spouse simply inherits everything. In a majority of situations, that is not actually true. In 30 states, plus the District of Columbia, if the deceased person had a child from a relationship outside their current marriage, a child from a previous marriage, for example, that single fact automatically shrinks the surviving spouse's share of the estate. It doesn't matter how long the current marriage lasted. It doesn't matter how the family actually functioned or how close that blended family genuinely was. The formula doesn't ask any of those questions. It simply applies a fixed percentage split between the surviving spouse and the children from that earlier relationship. And in many cases, this produces a result that would have genuinely surprised and likely upset the person who passed away had they known in advance exactly how the formula would apply to their specific situation. The second detail I want to make sure every single person watching this understands involves stepchildren, and this one carries real emotional weight for a significant number of blended families. Under intestate succession, stepchildren generally receive absolutely nothing, regardless of how close their relationship actually was, unless they were formally and legally adopted. Think about what this actually means in practice. A retiree who helped raise a stepchild from the age of 5, who was there for every school event, every milestone, every difficult moment across decades of genuine parenting, has no automatic legal right whatsoever to leave that stepchild anything under intestate succession, unless that adoption was formally completed at some point, or unless a will specifically named that stepchild as an intended heir. The same exact rule applies to foster children raised for years within a loving home but never formally adopted. The law does not recognize the depth or duration of an actual relationship. It recognizes only specific legal categories, and if you fall outside those categories, intestate succession simply does not see you as an heir, no matter what the reality of your family actually looked like. The third detail specifically affects any retiree with minor children or minor grandchildren under their care, and it's one of the most consequential aspects of this entire topic, precisely because it involves decisions about actual human beings, not just property. If both parents of a minor child pass away without a will, the state's probate court, not the surviving extended family, not whoever the family assumes would obviously step in, holds the legal authority to appoint a guardian for that child. Without a will specifically naming a preferred guardian, that decision is made entirely by a judge, someone who has never met your family, based on court proceedings and whatever evidence and testimony is presented, rather than based on your own actual wishes about who should raise your children if you couldn't. Family members can absolutely petition the court and make their case, but the court is not bound by any assumption about who the obvious choice would have been. This is precisely the kind of gap that a simple, properly executed will closes immediately and completely. The fourth detail involves something most people have simply never thought about, because it only becomes relevant in specific family situations: the treatment of half-siblings and half-relatives. In most states, half-siblings and half-relatives are entitled to only half the inheritance share that full-blood relatives receive under intestate succession. If a retiree has one full sibling and one half-sibling, and both would otherwise be entitled to inherit under the state's formula, the full sibling receives a larger share purely because of that specific biological distinction, regardless of the actual closeness or distance of either relationship throughout the person's life. The fifth detail involves timing, and it becomes genuinely important in tragic situations involving accidents or emergencies affecting multiple family members at once. Nearly every state imposes what's called a survivorship requirement, commonly a window of around 120 hours, meaning an heir must legally outlive the deceased person by that specific amount of time in order to inherit anything under intestate succession at all. This rule exists specifically to prevent property from passing back and forth rapidly between estates in situations involving simultaneous or near simultaneous deaths, but it has real, sometimes heartbreaking consequences for families navigating an already devastating situation, particularly when the exact sequence and timing of multiple deaths becomes legally significant to how an estate gets distributed. And finally, there's the rarest but most striking outcome of all, one that exists specifically as the ultimate legal backstop in every single state's intestacy code. If a person dies without a will, and the state genuinely cannot identify any legally qualifying relative at all, no spouse, no children, no parents, no siblings, no cousins, nothing, the entire estate escetes, meaning ownership, formally transfers directly to the state government itself. This outcome happens in fewer than 1% of estates, and states generally make real efforts to locate distant relatives before this occurs. But it remains, quite literally, the ultimate expression of what this entire video is about. In the complete absence of any legal instruction from you, the state does not simply guess at what you might have wanted. It follows its own formula, all the way to its most extreme possible conclusion. Let me walk you through a realistic example that shows how these pieces come together in a real family. Consider a retiree named Theresa, 69 years old, living in Georgia, who had been remarried for 18 years to her second husband, Michael. Theresa had one adult daughter from her first marriage. She and Michael never had children together, but Michael had raised Theresa's daughter as his own since she was a young teenager, present for her graduation, her wedding, and the birth of her own children. Theresa always assumed, without ever actually confirming it, that if something happened to her, Michael and her daughter would simply work things out together, and that her home and savings would naturally end up supporting both of them, exactly as their family had always functioned in practice. So here is exactly what I want you to do based on everything we've covered today. First, if you do not currently have a will, treat this as your sign to stop putting it off. This is genuinely one of the most consequential documents you will ever create, and it does not require immense wealth or complexity to be worth doing correctly. Second, if you have a blended family with children from a previous relationship, stepchildren, or foster children you never formally adopted, understand specifically that intestate succession may not treat your family the way you assume it will, and a will is the only way to ensure those specific relationships are legally honored. Third, if you have minor children, make sure your will specifically